You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Electronic Communications Privacy Act, or ECPA, was passed in 1986 to extend privacy protections to emerging digital technologies. It is a sprawling statute with three core components: the Wiretap Act, which governs real-time interception of communications; the Stored Communications Act, or SCA, which regulates access to emails and other stored data; and the Pen Register and Trap and Trace provisions, which cover dialing, routing, and signaling information. Each title reflects different expectations about sensitivity, scope, and due process. For learners, the ECPA illustrates the layered nature of communications privacy law. Rather than adopting a single framework, Congress recognized that live interception, stored email, and signaling data raise distinct issues. This approach, though forward-thinking in 1986, has since become strained as technologies like cloud platforms, mobile devices, and encrypted services stretch definitions that were once tied closely to telephone networks and on-premises storage. A central theme in the ECPA is the distinction between content and non-content information. Content refers to the actual substance of a message, what you write in an email or say in a phone call. Non-content, by contrast, includes metadata such as who you communicated with, when, and for how long. This distinction matters because the legal thresholds differ. Accessing content typically requires a warrant based on probable cause, while non-content records can often be obtained with a subpoena or lower-level court order. For learners, this demonstrates how privacy law scales protections in proportion to sensitivity. Content reveals intimate details of thought, belief, or behavior, while metadata is treated as less intrusive, though debates continue about whether metadata can in practice be just as revealing when aggregated across many interactions. The Wiretap Act, as part of the ECPA, is considered the most stringent portion of the statute because it authorizes real-time interception of communications. Investigators must show that the intercept is necessary, that other techniques would be insufficient, and that it is narrowly tailored to specific individuals or devices. Judicial approval is mandatory, and orders typically expire after 30 days unless renewed. For learners, this strict necessity standard reflects a recognition of the extraordinary intrusion posed by wiretaps. Unlike retrieving old emails, interception captures conversations as they happen, potentially exposing the most candid and sensitive expressions of private life. As a result, the Wiretap Act has become a symbol of high-threshold surveillance authority, rarely used but heavily scrutinized whenever invoked. The Stored Communications Act provides rules for accessing electronic data held in storage, such as email, text messages, or files on cloud platforms. It distinguishes between basic subscriber information, transactional records like IP logs, and the content of stored communications. The legal process required depends on the category. Subscriber records may be obtained with a subpoena. Transactional logs often require a 2703D order, and content demands a full warrant. For learners, this layered framework underscores how privacy law attempts to calibrate protections. It accepts that some records are less sensitive and may be produced under lighter scrutiny, while drawing a firm line around stored content, which requires the same probable cause showing as a real-time search. This distinction remains central, though modern storage practices challenge the clarity of these categories. Section 2703D of the SCA established an intermediate mechanism for compelling disclosure. A 2703D order requires the government to show specific and articulable facts that the records sought are relevant to an ongoing investigation, a lower bar than probable cause, but more substantial than a subpoena. These orders are often used for metadata such as email headers or IP logs. For learners, the 2703D process illustrates how the law provides a sliding scale of tools depending on investigative needs. It ensures that investigators cannot casually collect transactional data while still giving them an option short of a full warrant. This tiered structure reflects the balancing act between investigative efficiency and privacy protections, though critics argue that intermediate standards are easily met and insufficiently protective. Provider disclosure rules are another pillar of the ECPA. Service providers are generally prohibited from voluntarily disclosing user communications to the government without proper legal process. Exceptions exist for cases where users consent, where disclosure is necessary to protect the provider's rights, or where emergencies create imminent risks of death or serious physical harm. Providers also enjoy safe harbor protections when responding in good faith to lawful demands. For learners, these provisions highlight how the law enlists providers as both gatekeepers and cooperative partners. They must resist unauthorized demands while also enabling compliance with lawful ones. This dual role creates constant tension, as providers must balance user trust against obligations to government authorities. Preservation requests under the ECPA allow law enforcement to instruct providers to hold specific data pending the issuance of formal legal process. Providers must freeze the identified records for up to 90 days, renewable for another 90, ensuring that evidence is not deleted during the investigation. Importantly, preservation does not authorize disclosure. The data remains inaccessible until a warrant, subpoena, or order is served. For learners, preservation requests reveal how timing intersects with privacy. Investigators may not yet have sufficient cause for access, but preservation guarantees that relevant data will remain intact while they pursue authorization. This creates a careful balance between investigative need and user protection. The ECPA also recognizes emergency disclosure allowances in scenarios involving imminent danger. Providers may disclose communications or records without legal process if they reasonably believe it is necessary to prevent death or serious physical harm. This exception is designed for urgent cases such as kidnapping, suicide threats, or terrorist plots. For learners, the emergency provision highlights how privacy protections are not absolute. When human life is at stake, the law permits temporary shortcuts, trusting providers to act responsibly. Yet it also underscores the importance of documentation and oversight, as repeated or unjustified use of emergency exceptions could erode trust in both providers and regulators. Gag orders and non-disclosure directives often accompany ECPA demands, particularly those involving subpoenas or 2703D orders. These provisions prevent providers from notifying users that their information has been requested, preserving the secrecy of investigations. Courts may impose time limits, but gag orders can sometimes be extended for months or years. For learners, non-disclosure rules illustrate the tension between transparency and secrecy in surveillance. While secrecy protects investigations, it deprives individuals of the chance to challenge access in real time. Providers increasingly push back, seeking to publish aggregate statistics or challenge overly broad gag orders, signaling how the balance between privacy and security remains contested even decades after the law's passage. As organizations increasingly rely on enterprise email and collaboration platforms hosted by third parties, the Stored Communications Act has taken on new importance. Investigators may seek records from providers like Microsoft or Google, rather than from the enterprise directly, raising questions about who is the custodian of records. For learners, this scenario illustrates the complexity of modern business infrastructure. Privacy law must address not only traditional end-user communications, but also the corporate data environments where sensitive intellectual property, contracts, and internal conversations now reside. Providers and enterprises alike must carefully interpret the SCA to understand when and how data may be disclosed. Location information requests represent another evolving dimension of ECPA interpretation. Courts have struggled with whether precise geolocation data, often collected by cell towers or mobile devices, requires a warrant or a lower standard of process. The Supreme Court's Carpenter decision in 2018 ruled that accessing historical cell site location information generally requires a warrant, signaling stronger protections for location privacy. For learners, this illustrates how constitutional principles continue to shape statutory frameworks. The sensitivity of location data capable of revealing movements, associations, and habits has led to growing recognition that it deserves heightened protection, even when treated as metadata under older statutory schemes. Multi-tenant cloud architectures create new challenges for scope minimization under the ECPA. When user data is co-located on shared servers, providers must ensure that responses to legal process extract only the targeted records and do not expose unrelated information. For learners, this demonstrates how privacy compliance intersects with technical design. Cloud providers must engineer segregation mechanisms and logging systems that enforce minimization, ensuring that the principle of narrow disclosure is maintained even in environments where physical separation of data is no longer practical. This reflects how privacy safeguards must evolve alongside shifts in infrastructure. Cross-border data storage raises additional questions about comity and international conflict. When data is stored outside the United States but subject to ECPA requests, providers may face conflicting obligations between U.S. law and the privacy laws of the host country. Courts have grappled with whether ECPA applies extraterritorially, and frameworks such as the Cloud Act now provide mechanisms for resolving some conflicts. For learners, this reveals how privacy is not merely a domestic issue but a global one. Organizations must anticipate the diplomatic and legal implications of producing data across borders, ensuring that compliance with one regime does not create violations in another. Finally, evidentiary integrity is central to any disclosure under the ECPA. Providers must document each step of their response, maintain chain of custody, and log access to ensure that records are admissible in court. This requires technical and procedural safeguards that prevent tampering, demonstrate authenticity, and establish accountability. For learners, evidentiary integrity connects privacy compliance to broader principles of justice. Protecting records is not just about shielding individuals from overreach, it also ensures that when records are used in court, they are reliable and credible. Documentation, logging, and custody practices thus protect both individual rights and the fairness of judicial proceedings. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Communications Assistance for Law Enforcement Act, or CALEA, was enacted in 1994 to ensure that telecommunications carriers could provide lawful intercept capabilities when presented with valid legal process. CALEA does not authorize surveillance on its own. Rather, it obligates carriers to design and maintain infrastructure that allows court-ordered interceptions to be implemented effectively. Covered entities include traditional telephone companies, broadband providers, and voice-over Internet protocol operators, reflecting a technology-neutral expectation that providers must enable lawful access regardless of the medium. For learners, CALEA represents the structural side of compliance. It is not about deciding when access is granted, that is left to judges and investigators, but about ensuring networks do not obstruct lawful orders through technical design. This principle reinforces the idea that privacy protections and investigatory powers coexist through engineering choices and legal checks. Technical standards play a crucial role in enabling CALEA compliance. Carriers rely on standardized handover interfaces and intercept mediation platforms that capture and deliver communications in a format investigators can use. These platforms ensure separation between operational networks and intercept functions, minimizing risks of disruption. Standards also define how content, metadata, and signaling information are extracted, ensuring consistency across providers. For learners, these standards illustrate how compliance is operationalized through technical blueprints. Just as aviation relies on standardized safety systems, Lawful Intercept relies on uniform processes that make cooperation predictable and defensible. Standardization also demonstrates how privacy is preserved through minimization. Intercept systems are designed to capture only what is authorized, reducing the risk of over-collection or collateral exposure. CALEA also addresses the practical question of cost. Carriers are allowed to recover reasonable expenses incurred when provisioning lawful intercepts, ensuring that compliance does not become an unsustainable financial burden. Timelines for provisioning are also specified, reflecting the urgency of many investigations. Assistance duties extend beyond provisioning, requiring providers to coordinate actively with investigators during intercept operations. For learners, these provisions highlight how compliance involves both technical readiness and organizational cooperation. Privacy protections are maintained by ensuring intercepts are only activated when valid orders are presented, but once active, carriers must ensure that investigators receive reliable data streams without unnecessary delay. This balance between duty and sustainability reflects how compliance frameworks attempt to align private sector capacity with public sector needs. As communications technologies evolve, questions about coverage under CALEA continue to arise. Initially focused on traditional telephony, the law has been interpreted to cover broadband internet providers and certain VoIP services, recognizing that voice and data increasingly converge. For learners, this expansion underscores the technology-neutral nature of lawful access obligations. It does not matter whether a conversation occurs on copper wires, fiber optic lines, or digital apps. The principle remains that carriers must enable lawful intercept when served with valid orders. However, the boundaries are constantly tested as new services emerge, from encrypted messaging platforms to decentralized communications. CALEA reflects the struggle of law to keep pace with innovation while maintaining the consistency of its obligations. Intercepts can involve both metadata and content. Metadata includes information like call logs, signaling events, and routing data, while content refers to the actual voice or text of the communication. Providers must deliver both types of information in structured formats that investigators can analyze. For learners, the distinction mirrors broader privacy law debates. Metadata is sometimes treated as less sensitive, but in practice, it can reveal deep insights into behavior and association patterns. Lawful intercept systems must therefore be engineered carefully to capture exactly what orders authorize. No more, no less, ensuring compliance with minimization rules while still enabling investigative utility. Encryption presents one of the thorniest challenges for lawful intercept under CALEA. The law requires carriers to provide access where they hold or manage encryption keys, but it does not obligate them to break encryption if they lack control. This creates a critical dividing line. Traditional carriers may comply, but end-to-end encrypted services often cannot, by design. For learners, this debate highlights the intersection of privacy, security, and law enforcement. Encryption protects users from cyber threats and espionage but also frustrates lawful investigations. CALEA reflects a compromise by obligating providers only to the extent they control decryption capabilities, leaving unresolved tensions about how to reconcile strong encryption with lawful access needs. Minimization and targeting controls are fundamental safeguards during lawful intercept operations. Investigators must tailor intercepts to the specific individuals, devices, or accounts named in the order, and providers must implement technical restrictions that prevent unauthorized spillover. Audit controls log every intercept activation, providing evidence that orders were followed faithfully. For learners, these requirements embody the principle of proportionality. Intercepts are extraordinary measures, and their use must be limited precisely to the authorized scope. Logging ensures accountability, enabling oversight bodies to verify that privacy rights were respected even while investigative powers were exercised. Minimization transforms legal theory into technical enforcement, bridging law and engineering in practice. Globalized communications add further complexity. International roaming, peering arrangements, and cross-border service models often mean that data relevant to an intercept may traverse multiple jurisdictions. Providers must navigate conflicts between CALEA obligations and foreign privacy laws, sometimes relying on treaties or comity principles to reconcile demands. For learners, this challenge illustrates how privacy governance is no longer bounded by geography. An intercept order issued in one country may depend on infrastructure or storage in another, forcing providers to balance compliance with potentially conflicting obligations. Cross-border complexity reinforces the importance of international cooperation and the need for harmonized frameworks that respect both sovereignty and privacy. Mistakes during intercept operations, such as misprovisioning an order to the wrong account, can have serious consequences. Providers are expected to maintain incident response plans to detect, correct, and document errors quickly. For learners, this demonstrates that lawful intercept operations require the same rigor as cybersecurity incident management. Errors not only compromise privacy but can also taint evidence, undermining prosecutions. Remediation obligations reinforce accountability by ensuring that mistakes are addressed transparently and processes improved to prevent recurrence. Incident handling in intercept operations reflects the broader privacy principle that governance must anticipate failures and embed resilience. Civil discovery pressures create another area of tension. While intercept platforms are designed for government access under lawful orders, litigants in private lawsuits may seek similar information through subpoenas or discovery demands. Providers must maintain strict separation between lawful intercept functions and civil disclosure processes to prevent misuse. For learners, this highlights how privacy depends on role boundaries. Intercept systems serve one purpose only: compliance with judicially authorized government surveillance. Mixing them with civil litigation would erode trust, compromise evidentiary integrity, and risk creating de facto surveillance outside statutory safeguards. Separation protects both privacy and the legitimacy of lawful intercept operations. Customer notice prohibitions are another defining feature of lawful intercepts. Providers are generally barred from informing individuals that their communications are being intercepted, ensuring investigations remain covert. Only after investigations conclude, and sometimes never, may limited disclosures occur. For learners, this illustrates the profound tension between privacy rights and investigative secrecy. While secrecy undermines transparency, it is seen as essential to protect the efficacy of surveillance. The prohibition on notice reflects a societal decision that privacy protections during intercepts must come from judicial oversight and minimization, not from contemporaneous transparency. Vendors who supply intercept platforms are also subject to scrutiny. Providers must ensure that systems used for lawful intercept are secured against misuse, unauthorized access, or exploitation by insiders. Vendor management includes contractual obligations, audits, and security testing to ensure compliance. For learners, this emphasizes how privacy governance extends across supply chains. Trust in lawful intercept depends not only on laws and carriers, but also on the integrity of vendors who design and operate the technical systems. Security of intercept platforms is critical to preventing them from becoming tools of abuse rather than lawful compliance. Governance alignment among legal, security, and network operations teams is the final layer of effective intercept management. Requests must be verified legally, implemented technically, and secured operationally, with all teams coordinating closely. Misalignment risks either overcompliance, where too much data is disclosed, or undercompliance, where lawful orders are not properly fulfilled. For learners, this demonstrates the organizational dimension of privacy and surveillance governance. Effective lawful intercepts require not only statutes and technology, but also cross-functional collaboration within providers. Governance alignment ensures that privacy, legality, and operational integrity converge, reinforcing trust in a process that sits at the heart of the tension between individual rights and government authority. In conclusion, CALEA and lawful intercept operations illustrate how privacy rights and investigative powers coexist through structured processes, technical safeguards, and organizational governance. Providers must ensure that systems enable lawful compliance without enabling abuse, balancing secrecy, minimization, and accountability. For learners, the lesson is clear. Communications access is governed not by absolute rights, but by calibrated processes. ECPA defines thresholds for legal process, while CALEA ensures technical capability. Together, they demonstrate how privacy in communications is protected through a combination of law, engineering, and disciplined governance, ensuring lawful access remains bounded, secure, and proportionate. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.